Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi taala wabarakatuh, and selamat sejahtera and good evening to all. My name is Ruzita Azmi from UMKL campus, and my topic today is the Employee Assistance Program in Malaysia and the United Kingdom, a method for addressing mental health issues at work. This paper actually is one of the findings from our research funded by Ministry of Education through Fundamental Research Grant Scheme. Okay, as an introduction, Employee Assistance Program, or known as EAP, was previously known as Occupational Alcohol Programs, introduced by the American employers with a specific aim to cater alcohol abuse among the workers. Currently, the implementation of EAP widely covers various occupational issues. Among others include the work-related stress problem in a workplace. The application of EAP is in line with the provisions of Article 27 of Charter of United Nations in relation to work and employment, which provides protection to the employee to have a just and favorable condition at work for safe and healthy working conditions. So, what are the objectives of EAP? The objective of EAP generally focus mainly on giving professional advices and consultation in helping both employers and employees dealing with problems such as mental health issues relating to work that may affect the employee's performance. The introduction of EAP is claimed should act as a prevention and intervention mechanism for employees who are dealing with work-related stress. EAP and Employee Assistance Professionals Association, or is known as EAPA. The importance to have an EAP can be seen in the introduction of Employee Assistance Professional Association, EAPA. EAPA later issued EAP standard framework to secure the effective implementation of EAP itself. In ensuring the employee's mental health well-being, both Malaysia and the United Kingdom have adopted EAP, each with its own different mechanism. Accordingly, this paper seeks to explain on the application of EAP in Malaysia and the United Kingdom, as well as the limitations of its application. The question arises: is EAP based on any statutory footing, or in other words, if there is any specific requirement under our law that mandates for this program? It should be noted that there is no specific requirement under Malaysian legal provisions mandating for EAP. However, it is important to note Section 15, Clause 2 of the Occupational Safety and Health Act 1994 has impliedly supported the introduction of EAP in Malaysia, stating that every employer is required to ensure their employees' safety, their employees' health, and their employees' welfare at work. So based on this provision, this is the ground for employer to help employee who have problems, to include mental health issue that has been affected by work or any work-related stress that could trigger their mental health problems. EAP affiliates and models in Malaysia. So we want to know what are the models for EAP in Malaysia? The EAP affiliates in Malaysia include the MIND, the program of Mind Psychology, Bosch, Workplace Options, Naluri, and Solace Wellness. Among the available EAP models applicable in Malaysia are in-house program, fixed fee contracts, fee for service contracts, and hybrid model. What is the in-house program? This is one of the models of EAP that available in Malaysia. The in-house program is a type of EAP that hires professionals to be attached to an organization in which the confidentiality of employees is claimed to be protected. Meanwhile, fixed fee contracts deals with external consultant, wherein their fees are paid based on the total number of employees, regardless whether the employees have been consulted or not. Fee for service contracts are based on fees are paid on the total number of the consultation session provided. Alternatively, employers may apply the hybrid model, which utilize the combination of all EAP model. So it means that it could be the in-house program together with fixed fee contract. It could be fixed fee contracts with fee for service contract, and could be the in-house program and fee for service contracts. It should be noted too that leading and outstanding companies in Malaysia, such as Shell Malaysia, has adopted employee assistance program by providing counseling support services in form of preventive and proactive intervention to their employees facing mental health problems, which may affect their work performance. Similarly, TM Malaysia has also adopted EAP in the form of counseling services to cater its employees' personal or work-related problem. So, what is the achievement of the EAP? In other words, is there any companies in Malaysia that have achieved something under EAP program? So, Shell Malaysia is one of the company that have achieved in terms of helping their employees through EAP program. This can be proved as one survey conducted entitled What Working Parents Want 2020 has awarded 10 Malaysian companies, including Shell Malaysia, that offers counseling services for its employee as family-friendly companies. Such counseling services are considered as an important element of EAP as the employee supportive program in ensuring their mental health well-being. Interestingly, the counseling sessions are conducted in different languages to cater the need of the multiracial employees that speak diverse languages such as Malay, English, Mandarin, Tamil, Cantonese, and Hokkien. If earlier we discussed about EAP in Malaysia, now we want to look into EAP in the United Kingdom. EAP is widely applied in the UK as a mechanism for employers to help the workers in dealing with work-related and non-work-related stress. In order to ensure that the distinguished services as well as quality of EAP, a standard framework has been introduced by EAPA. So, similar like Malaysia, when come to the standard framework of EAP, in UK, the standard framework has been introduced by EAP too, although it is not legally binding. The standard framework requires, among others, that the purchaser of EAP is usually an organization or the companies, whereby as the purchaser of EAP to be supplied with implementation plan, promotion, report, complaint procedures, record keeping, confidentiality, EAP specialists, and many more. So this is the standard framework requires for employee assistance program. So we want to know what are the types of EAP in the UK. It can be divided into three types. First, external. Second, internal EAP. And third, embedded EAP. External EAP model is a program whereby employees will be given advice by a counselor or psychologist at a location away from the workplace, which provides more ease, more comfort to the related employee, as the colleagues are not able to notice the session. Internal EAP is taken place through counseling session given by a therapist within the workplace surrounding. So we can see that it can see the difference between external and internal types of EAP in the UK. But last but not least, embedded EAP model. This model carried out free of charge for the employee, usually provided through telephone helpline as part of insurance bought by the employer. What is the ideal and good EAP? We also would like to discuss what are the ideal and good EAP. It is recommended that the ideal and good EAP should mandatorily consist of the employment of in-house counselor, manages continuous monitoring, and preventive approach. A research conducted by Dr. Sofia Bajorek in 2018 has pointed out that the application of EAP could improve employees' productivity by reducing absenteeism rate in an organization. The finding of the research, among others, claim that there are positive feedbacks from employees towards EAP as being captured from interview session with them as the following. Sometimes staff do not want to discuss their personal matters internally, so the EAP gives them that service, that place to go, where they can be anonymous and discuss their problems. EAP can be used as a mechanism. It also can be used as a tool for employer to help employee whereby the assistant will contribute to a healthier employees since they feel the employer appreciate them. We also want to discuss about the effectiveness. That's why this slide discuss on the evaluation on the effectiveness of EAP in the UK. Is it effective? It is said that it is not reliable since it is carried out through informal ways. For example, staff rating, the number of closed cases, and sickness absence, other than quarterly meeting between provider of EAP and the employer, which is less evidence. Moreover, there are constraints or limitations for effective implementation of EAP, and due to many reasons. The constraints for effective implementation can be divided into four. Firstly, D is considered the constraint for effective implementation of EAP in the UK. Why? This is due to sessions are limited as it is based on the employer's income stability. The more income of the employers, the more number of counseling sessions can be attended by the employees. Basically, therapy services for employees are accessible for only 9 days on the average, which involve 4 to 6 sessions only. So this is the first hurdle. This is the first constraint because as we are aware, this program has some cost to be what we call to be uh, to be paid by the employers. Yeah, so that's why it is said here. It depends on the employer's income stability, meaning that the richer the employer, the more number of counseling session can be attended by the employees. Secondly, the fees charged for every session are costly, despite some of the sessions are conducted only through telephone. So this is an issue in the UK, especially uh, during COVID-19 pandemic. It is said that the affiliate did not need to pay for transportation. They also did not need to pay for the accommodation. So the fees must be revised. It should be reduced due to this constraint, due to this restricted movement during COVID-19. The cost of an EAP is at approximately £5 to 15 per head, depending on which service is provided by the affiliate, whether it is online or face-to-face. Thirdly, the range of issues handled by the affiliates are limited only to the problems that are encountered by individual employees, or only subjected to the training or competency of the counsellors. Therefore, conflict and concerns regarding the negative stigma on the confidentiality of EAP will not be entertained by the affiliates. In addition, advice given by the non-competent advisor regarding the issues faced by the employee might also affect the effectiveness of EAP. EAP also is less effective when the factors contributed to the employee's work-related stress discussed with the EAP provider were reported to the top management of the organization. So this is one of the factors that make uh, or limit the effectiveness of the implementation of EAP, since the cases were reported to the top management of the organization about the work-related stress suffered by the employees. Such factors may be caused by the surrounding of the workplace or could be the employee's personal life. However, this might be inaccurate due to the wrong perception or misunderstanding of the employee towards the issue happening at the workplace. The acceptance and stigma of the employees towards EAP may also contribute to the less effectiveness of EAP. Now we would like to discuss about EAP and employers' duty of care. The implementation of EAP can be considered as a way to support the employer in dealing with employees' mental health issues. Accordingly, it is the employer's duty of care to cater the employee's mental health issue, which could which should consist of safe working environment by avoiding issues pertaining to work-related illness, breach of duty to conduct risk assessment, and provide consultation may contribute to legal implication, as it is a statutory obligation reflected under the UK Health and Safety at Work. We also has discovered two cases related to the duty of care of employer. The first case is Walker versus Northumberland City Council 1995. In this case, what happened was that the employee, due to overwork and stress, had reported the problem to the council as his employer. So the employer was the Northumberland City Council. So despite the employer's promise to look into the problems, nothing was done to solve the problem. The council's failure to provide resources to reduce the pressure and to allow the employee to provide the necessary services had driven the employee to despair, while the employer's first nervous breakdown could not have been foreseen, the employer should have anticipated that the same workload was likely to lead to a further breakdown and subsequent end of the employee's career. The standard of care required by the council mean support should have been forthcoming, but it was not. The court ruled that the council was in breach of its duty of care with liability for damages were to be assessed. The second case, in the case of Barber versus Somerset County Council, in this case what happened was that Mr. Barber was employed by Somerset County Council as a teacher. As a result of a restructuring process in September 1995, Mr. Barber had taken on further responsibilities and had to work between 61 and 70 hours weekly. In February 1996, he complained of work overload to the school deputy head teacher. Consequently, in May 1996, he was absent from work for 3 weeks due to stress and depression. On his return to work, Mr. Barber met with members of the school senior management team and said he was not coping with his workload and his health was affected. Unfortunately, no steps were taken to help him. In November 1996, after losing control and shaking a student, he left the school and did not return. Since then, Mr. Barber had been unable to work as a teacher or to do any work other than undemanding part-time work. He claimed damages for psychiatric illness. Somerset City Council appealed to the Court of Appeal after the judgment was in favour of Barber at the county court. Eventually, it was further brought to the House of Lords, wherein the House of Lords, the highest court in England, stated that the overall test in determining whether an employer was in breach of the duty of care owed to an employee was the conduct of a reasonable and prudent employer taking positive thought for the safety of its workers in the light of what it knows or ought to know. Every case depended on its own facts, the court said. Later, the House of Lords decided that the employer's duty to take some action arose when Mr. Barber returned to work after a 3-week absence due to stress and depression and met with the school senior management team. It continued so long and nothing was done to help him. The House of Lords restored the county court decision as the case was concluded that Mr. Barber's depressive illness was caused by stress at work. He was awarded damages of over 100,000 pounds. Another question arises. Is EAP program proactive or reactive? In exercising the duty of care, an employer should be very proactive rather than implementing the wait-and-see approach. Proactive steps must be taken by the employer to help employees who are suffering stress from the workplace. Accordingly, the implementation of EAP towards successful employees' mental health well-being in supporting employers' duty of care should encompass at preventive level and not only at reactive level. And such support mechanism should cover the right person in the right way and right time and accessibility. These are our recommendations. The employer applies EAP, it should also be efficiently promoted among the employees. An organization should convince the employees to obtain consultation from the EAP counselors and assure that there will be no work discrimination posed on the employees by the employers since the problems shared are strictly confidential. The evaluation method to prove the cost effectiveness must be developed in ensuring the efficiency of EAP. However, this should not be the prime concern in assessing the effectiveness of EAP, but rather the employee's mental health well-being must be prioritized. The EAP success should not be justified only by considering at the rate of employees' absenteeism. Other than implementing EAP, employees' mental health well-being can alternatively be supported by several other mechanisms to ensure that it does not only act at the reactive level, but also at the prevention level. As a conclusion, the application of EAP in an organization can promote the mental health well-being of employees. However, it should be noted that employers need not to be advocated with the advantages and benefits of utilizing EAP in assisting their employees experiencing with work-related stress issues. Effective EAP is not only beneficial to the employees, but may also contribute to the increase of organizations' return on investment, ROI. Finally, substantially, companies with the best practice of EAP can be referred to as implementation guidelines as far as EAP program is concerned. That's all from and thank you. Is it?